Tarini Arogyaswamy, and I'm the subject head for LEAP, which is one of the topics in the PGDLPO diploma course on legal process outsourcing. As you know, in addition to LEAP, we have 3 other topics, which is VIM, SPEED, and PEP. The subject heads for each of those topics will be giving a contact session in the next few days as well. I'm going to start off by just saying that if you have any doubts or if you have any queries relating to the contact session today or any of the materials, please post them on Virtual Classroom. We really do look forward to your queries, and answering those makes a huge difference to us to know where exactly there are gaps and where exactly students are having problems. In fact, I would prefer, if you have queries today, you could note them down and post them on Virtual Classroom. I would like to just go through the session today and deliver the material that I would like you to focus on, which I'll start off with the formation of contracts. That's the last 2 PDF documents that we added. I just want to give everyone a review of that material. At the end, if we have time, I'm going to go through a review of the US legal system, which is another important topic that we covered. We'll look at first what contracts are, what a contract is, how a contract is different from an agreement. An agreement is enforceable by law, which means it is then a contract. If it's not enforceable by law, it's not a contract. For instance, we may have agreements with our friends to go to a movie, to go out for dinner. Those will not be considered contracts. Those agreements are not enforceable by law. The major difference would be that for a contract, the parties intend to enter into a legally binding arrangement. So trivial issues, minor agreements, those are not considered contracts. Contracts involve a 3-step process. The first step of this process is the formation of contracts. As it says on the slide, this step of the process involves looking at when can we say that a contract has in fact been formed. What are the essential requirements that need to be fulfilled in order for us to be able to say that there is a contract, that there's just not an agreement. There is an agreement that is enforceable by law. The second step of the process is what each party to the contract has to do in order to fulfill the contract. When can we say that a party has done everything possible that they were supposed to do under the contract? When do we know that a party is not fulfilled under the contract? The third step of this process is breach. This looks at what happens when parties don't do everything they're supposed to do under the contract. What are the remedies available for the injured party? Is it money or is it some other remedy? Let's look at the first step of this process, formation of contracts. There are 2 fundamental elements that are absolutely necessary. You have the offer and you have the acceptance. The offer is the willingness to enter into a binding legal arrangement. The offer and the acceptance must both be clear, complete, and communicated. What does it mean for the offer and acceptance to be clear? It must be clear, meaning that all the terms must be clearly laid out. It must be clear to the parties what is being offered and what is being accepted. It must be complete. The offer and acceptance must be complete, meaning that all the terms must be complete. The price term should be given. If there's a quantity term, a location term, all of those should be given. There should be nothing left up to doubt. In addition, the offer and acceptance must be communicated. If an offer is made unless the other party knows about the offer, how can he or she accept it, and how can anyone say that it's been accepted? The last part of an offer and acceptance is that by giving an offer, the party is saying they want to enter into a legally binding arrangement, that they're willing to back up their statement, their offer. If they make a statement saying, I promise to do this, are they willing to stand by it and to deliver on it, and to suffer the legal consequences if they don't do what they have promised? In addition to offer and acceptance, we also have conditions that are required for the contract to be valid. Once the offer and acceptance are made, the agreement is recognized as a contract. However, for the contract to have validity, to be continued to be recognized as enforceable by law, these conditions must be met. There are 4 conditions. The first condition is lawful consideration. The second condition, competence of parties. The third one, lawful object. And the fourth one, consent. All 4 have to be met. If even one of them is not met, the contract is not legally valid. The contract is void. Let's look at these one by one. Lawful consideration. It's not the same as object, as the purpose. The law will not support a contract without consideration. The requirement is not that consideration be adequate, but rather that consideration is something of value in the eyes of the law. Therefore, consideration may be defined as some interest, profit, benefit that one party gets, or a detriment, a forbearance, a loss, or a responsibility incurred by the other party. In fact, a consideration can take the form of a promise, a performance, or a forbearance. One party may promise to abstain from doing an act or do an act if the other party agrees to that act or that abstinence. Consideration, in other words, is an exchange of promises, an exchange of a promise for a forbearance. It is a quid pro quo situation. 2 parties agree to do something in order for the other party to do something else. Most situations involve reciprocity of consideration. Consideration going from both sides, from both parties. Involves promises from both sides, perhaps. There's also the situation of promissory estoppel. This is the situation where there's only a unilateral promise, a promise from one side. However, based on that unilateral promise, the other party changes his or her position in some way. Therefore, there is a promise on one side and foreseeable detrimental reliance on that promise from the other party. In that situation, the promisor, the person who made the promise, cannot walk away and say, I never asked the other party to do anything in exchange for my promise. The promisor is responsible and is obligated to the promisee, the person who delivered on the promisor's promise. The promisor cannot walk away by saying there's no consideration, rather, because the promisor is bound due to promissory estoppel. The next condition that's required is lawful object. Lawful object looks at the purpose of the agreement. Why is the agreement being entered into? What is the purpose, the reason behind the parties entering into that contract? The law will not support a contract with an illegal object, with an illegal purpose. For instance, if 2 people enter into a contract to have someone killed, the law is not going to enforce that contract. That is a contract with an illegal purpose. Indian Contract Act provides a list of unlawful objects. So, the object of an agreement is lawful unless the object is fraudulent. The court finds that it is immoral or opposed to public policy, that it would cause injury to the person or property of another. Most importantly, lawful object is important to distinguish from the consideration for the contract. Consideration and object may often be similar. However, consideration is the price paid for the promise. The promise made by one person is followed by the price for that promise, which is the consideration. The next condition that we look at is competence. Indian Contract Act provides the following broad categories of persons as incompetent. That means that Indian Contract Act states that there are certain people who are incapable of entering into a contract. They're incapable of making an offer and making an acceptance. Competence means a way at looking at whether the people can make a decision and make a rational judgment as to the effect of that decision on their interests. The categories are, under the Indian Contract Act, minors, mostly considered under 18 unless the court has given the minor under 18 a guardian, at which point becomes 21. Persons of unsound mind, those who cannot make the decision and rationally judge the effect of that decision on their interests. And other people who are forbidden by law. There are certain exceptions. For instance, if an incapable person contracts for necessaries, which are food, shelter, clothing, maybe medical goods, the person who delivers or provides those necessaries may be entitled to be reimbursed by the incapable person for those necessaries. Therefore, the incapable person cannot just walk away because they are considered incapable. The next condition that we must look at, which requires to be fulfilled, is consent. What it means is that the parties entering into a contract must have agreed to enter into that contract with consent. They must have consented to enter into the contract. Consensus ad idem. I'm sure you've seen that in the materials posted on eMentor and also in the materials you received in the mail. It means that both parties must agree upon the same thing in the same sense. Now, there are two situations that could happen in regards to consent. The first one is where there is no consent at all. Either the two parties agree to two different things, or they may agree to the same thing but in two different senses. Therefore, there is no consensus ad idem. They have not agreed upon the same thing in the same sense. In these situations, there is no contract. It is a legal nullity. If a contract is arrived at, it's a legal nullity. It's considered void. One party has made an offer, but it's important that the other party knows what that offer is and accepts it on those terms, consents on those very terms in the same sense. If they do not, that is a no consent situation. They have not consented to the terms as they stand. Often, an offer is made, and instead of accepting, the other party makes a counter offer, offers new terms. That's not an acceptance of the original terms. That is an offer of new terms. It's a counter offer. Therefore, there's no consent between the parties to the same thing in the same sense. There could be invalid consent situations. No consent happens in some types of mistake, which time, as I mentioned, the contract is void. Invalid consent means that the parties may have consented, but they have not consented freely. Free consent indicates the absence of legally vitiating factors that force that party to consent. Free consent would mean that a party has consented without any force or pressure, mental or physical. They've agreed to the terms of their own free will. Invalid or no free consent situations happen in the case of coercion, undue influence, misrepresentation, fraud. We'll take a look at all of these individually now. No consent situation means there's no consent at all in the eyes of the law. There may be apparent agreement. The parties are thinking something completely different from each other. It involves situations of mistake by one party and that the other party is aware of that mistake. It may be a mistake as to identity, why identity is essential to the contract. Maybe the identity of a person or a thing or an organization. A party may think that this person is an architect and enters into a contract because of that, gives his consent to the architect because he thinks he's an architect. However, that person may be an engineer. That's a mistake made by one party as to identity, and the identity is essential to the contract because the person wants the services of an architect, not of an engineer. The mistake could be as to the document being signed. Maybe the party thinks that they're signing a divorce agreement, but in fact they're signing adoption papers. There's a mistake as to the document being signed, as to the terms of the document, as to what the document is. We have invalid consent situations, also involving some types of mistake, where both parties to an agreement are under a mistake as to a matter of fact essential to the agreement. Here you have mutual mistake. Both parties are making the mistake. In the previous situation, we had no consent situation involving mistake where it was mistake by one party and the other party is aware of the mistake but isn't making the same mistake. Here we have both parties are under a mistake as to a matter of fact essential to the agreement. There are three types of situations where the mistake is to a matter of fact, and what are those facts that are essential to the agreement. The first situation could be mistake as to existence of or title to subject matter, mistake as to substance as opposed to merely quality, mistake regarding fundamental assumption. Let's look at these separately. You may have a mistake as to existence of or title to subject matter. For instance, A is trying to sell goods to B, but goods have been destroyed. Or A is trying to sell goods to B, but he doesn't have title over them. In that situation, both A and B are under a mistake situation. There's a mistake as to the existence of or the title to subject matter. Those goods don't exist anymore. So when they enter into the contract, the goods have already been destroyed. Those goods do not exist anymore. The second situation, the person no longer has title. Maybe they've been sold before. Maybe they've been stolen. Maybe he had stolen those goods that he's trying to sell now. There are many situations that can arise. Mistake as to substance as opposed to mere quality. The mistake must go to the heart of the subject matter. An example would be, if parties are mistaken about the historic value of certain table napkins, the fate of the contract will depend on the following. Did they make a mistake as to substance? If the intention was to buy and sell table linen, then the contract will still be valid. However, if the intention was to buy and sell historic relics, and possibly those are not historic relics, then the contract will be invalid because there was a mistake made. That's a mistake as to substance, not quality. What is the substance of those goods? If the parties were looking to sell and buy historic artifacts and they are not in fact historic artifacts, the contract will be invalid. Last situation, mistake regarding a fundamental assumption, where parties have by clear expression converted a matter of quality into a matter of substance. Let's look at the invalid consent situations, which could happen for a few different reasons. Invalid consent looks at whether there was some legally vitiating factors that will make the contract voidable, which means that the party that did not give free consent, whose consent is considered invalid, that party has the ability, the right to reject or to accept the contract. However, until that party rejects the contract, that contract is valid and is enforceable. That's why it's called a contract that is voidable. In the earlier situation where we looked at mistake, the contract is void. It is a legal nullity. In that situation, the contract is considered as if it never existed, and the parties are put back in the position they would have been in if they had never entered into the contract. Here, invalid consent situations, a legally vitiating factor, a factor that could make the contract voidable, is misrepresentation, false representation. It could be a statement, or it could be even through silence. We also have another legally vitiating factor which could make the contract voidable: fraud, similar to misrepresentation, different because it involves deliberate false representation. Misrepresentation is not deliberate. Fraud is. Therefore, it cannot be through mere silence. It has to be through active concealment. The party does something to deliberately, purposefully, actively conceal something which would change the other party's mind, which would possibly lead to the loss of an agreement. The parties would not go ahead with the agreement. The core principle is the contract is vitiated only if misrepresentation or fraud caused the consent. So the court will have to look at whether the misrepresentation or the fraud was the reason why the other party consented. If the misrepresentation or the fraud is not the reason for the consent, if the party would have consented anyway, then we cannot say that the contract is vitiated, that that was a legally vitiating factor, that was the reason for the contract to be voidable. We'll look at an example. The core principle here, as we discussed in the last slide, is put into effect. Suppose we have an LPO that tells the client three things. First, that our lawyers all have master's degrees. Second, that they all have 3 years experience in litigation support. And third, that they all are experts in US intellectual property law. We need to get to the heart of the matter, to the subject matter. Now, if these 3 promises or statements that the LPO has told its client caused the client to enter into the contract, then these statements are, of course, the reason for the contract to be vitiated. Therefore, the misrepresentation and the fraud made here would cause this contract to be voidable by the client. The client would have the right to reject or accept the contract because the LPO has made a misrepresentation. In this case, has committed a fraud, deliberately concealed the truth, deliberately represented that which is not true, if in fact these facts are not true. If these facts are true, of course, the contract is valid. However, if the LPO is deliberately misrepresented to the client, then we have a situation where the contract can be vitiated, can be voidable by the client. We would say that there are legally vitiating factors present that make this contract voidable. The legally vitiating factors in this situation was that the consent was arrived at through misrepresentation and fraud. However, if the client would have entered into the contract regardless of these statements made by the LPO, if it can be shown that the consent was not given because of these statements or these facts proposed by the LPO, then the contract will remain valid. They are not then legally vitiating factors. Another legally vitiating factor is the situation involving coercion. Coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. For the first one, we can look at threatening to commit suicide. Threatening to commit suicide. Suicide is an act forbidden by the Indian Penal Code. Therefore, threatening to commit suicide is an act of coercion. Similarly, threatening to institute prosecution for some crime is also an act of coercion. It's possible that someone tells someone else that I will institute prosecution for some crime you've committed unless you enter into this other agreement. Unless you enter into this agreement with me, you fulfill this act, you deliver this promise. That would be an act of coercion. As you can see from the picture on the right side, with the man holding the gun to the other man's head, an act of coercion. Insisting that he enter into the agreement because otherwise he will commit or threaten to commit an act or detain him or do some other forbidden act unless he enters into the agreement. Another situation involving invalid consent is undue influence. A contract is said to be induced by undue influence where the relations existing between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. This could be a situation involving authority, people with authority, fiduciary relationships, or if the person's mental capacity is temporarily or permanently affected by reason of illness, mental or bodily distress. The two elements involved here are position to dominate the will of another and the abuse of that position. In the case of a fiduciary relationship, for instance, a fiduciary is someone who has authority over another. For instance, it may involve a lawyer and his client. A lawyer and a client are in a fiduciary relationship. Similarly, a doctor and his patient are in a fiduciary relationship. The doctor is in a position of authority and of trust. The patient looks to the doctor for authority, for decision making, for assistance, for counseling. Therefore, the doctor is in a position to dominate the will of the patient and also may be able to abuse that position of authority. A fiduciary relationship, the doctor may be able to assert undue influence and take advantage, unfair advantage over the patient. Similarly, in situations of real authority, it's possible that someone holds themselves out as the authority on a certain arena or an industry And so that person may have the power to dominate the will of that other person in that industry because they hold themselves out as authority, as having expertise, and they are able to abuse that position in relation to that person. It could also be because of mental capacity being temporarily or permanently affected. Due to illness, due to age, a child may look up to a teacher or a parent or an elder person because their mental capacity may not be as developed as that other person. People who are mentally ill may also face undue influence from those who are in a position to dominate them and to abuse that position.